clause doesn't specify how the wildlife population assessment is conducted or how the quotas are allocated. Without transparency, Honorable Minister, it's very difficult to know if the quotas are set on sound scientific principles or if there is a risk of overhunting, Honorable Minister. Thank you.
Honorable Minister.
Thank you. Now we're back to the leader. Through you, Chair, with Madam Chikira Mabutami.
College.
Thank you, Chair, and thank you for your question. I'm going to try and describe the quota setting process and how transparent it is. So the quota setting process is done annually, like I said earlier, and this is in Zimbabwe. We use the participatory approach to quota setting. What it means is we make a call to advise on the dates and venue when the quota setting will be done. In the quota setting, we invite all stakeholders. All stakeholders, we start with the landowner where the wildlife is going to be handled. We invite the researchers, the internal and external researchers. We invite other government agencies. We invite the rural district councils. So when the quotas are done, the first stage is to collect all the information. And the information that we collect is on the species. We also look at the population estimates of each species. How do we come up with the population estimates? We conduct aerial surveys, which are done once every 4-5 years. We have quota settings that are done in all the key wildlife range areas. We also do ground counts at each individual property so that we come up with the numbers. So for each number that we have, we also have guidelines to guide us on the sustainable percentage that can be harvested for each species. When that has been done, the quotas are collected for the regions and they are approved by the minister. So we work also with the safari operators who are the people in the business and the landowners and the professional hunters and guides. So after we've done that in Zimbabwe, we also, as highlighted by the PS, we are also a party to CITES. We also report on the quotas that we have set. And when the animals are harvested, we also age them. For example, look at the lion, the leopard, we age them to assess whether they are hunting the correct trophy. Because if you hunt a young animal, it will have a negative impact on the population. We are killing the population. And monitoring is done. For example, for all the key species that are hunted, the elephant, the lion, the leopard, the buffalo, you are accompanied by a parks ranger or even a ranger from the RDC to ensure that the process is done correctly. And after a hunt has been done, you also submit returns to say, if you've given you a quota, for example, for all the species that we've harvested, you give us a return to say from the quota that we've given you, how much have you harvested and what is the balance. And we also do physical inspections, because when a hunt has been conducted, the trophy, which is mostly the skin and the skulls, that submitted to a taxidermy to process them, we also go and inspect. And when the trophy has been processed for export, we also have the ZIMRA coming in, the customs, and the security people also coming in to inspect. And in addition, for all hunts that are done in Zimbabwe, we have a Trust 2 system that is managed by the Reserve Bank of Zimbabwe. It ensures that whatever has been harvested has been accounted for. We look at the animals, the balance, and also at the finance side to say for this animal that has been harvested, how much of that has been harvested. And we've tried also to expand on the process in the bill as well. But if there's anything that could be missing, we're able to add as well. Because we added the definition which was lacking, and we've also added the type of species and animals that can be harvested. But certainly, if there's any addition that can be made, it can be added. Thank you, Chair.
Honorable Chair.
Thank you, Madam. Is that a supplementary, Honorable Jean?
Kind of, Honorable Chair.
Please go ahead.
Thank you, Honorable Chair. Sorry, I'll take you back to clause public input in everything. The clause doesn't mention any requirement for public consultation.
Thank you, Honorable. I think we will add that. Because during the quota setting process, it's an open workshop where everyone interested is invited, but we can also add it so that it's very clear in the bill. Thank you.
Thank you, Madam. So please, Pemsek, there is a lot of work that we need to do with this bill. And maybe to just also say that if things are not clear in this bill, we are missing an opportunity to actually come up with a very strong act, right? For example, this actually brings to conflict whereby Zimpax becomes a regulator and also becomes a player, right? Which is the major concern, because if there is no clarification in terms of how the quota system is going to be allocated, then it means Zimpax will be also allocating itself the quotas. So that has to come out clearly how the quota system is going to be done and how are the communities coming into play. We need clarification in the bill. Thank you, Honorable Cho, for raising that. Honorable Chinanjarana, please go ahead.
Thank you, Madam Chair. I would like to write on clause 9, section 16E, the composition of the council. We are a bit skeptical that isn't there limited stakeholder involvement. Only 3 of the members are wildlife professionals that are elected. What of the rest, the other 6, whose mandate, where is their mandate coming from? And what of also other stakeholders like the wildlife conservancies, all of the communities, where do they take part? If the 9 members of the council, only 3 are wildlife professionals. Let me just add on as well, Madam Chair, on section 16G there, the financial management. Aside from the 30% that are administration fees, it is hazy. There is no clarity on the remaining 70% and how it will be expended. There is need for clear spending guidelines, we think. I thank you, Madam Chair.
Thank you, Honorable Chinanjarana. Do you have a response there, Professor Matondi, or you have taken note?
Yeah, I've taken note, unless if my colleagues. Yes, you do it. Yeah.
Through you, Chair. Thank you very much, Honorable, for the question. I think on this one, we consulted with the industry, and I think we had a wider number of people, and it was a request for them to try to limit the number. And it's going to be up to them because we've got consumptive and non-consumptive. Consumptive is those who are into hunting, non-consumptive are those who are into photography. So they will have a representative. And what we've tried to do with this particular council is that they will have the responsibility of managing it. The other individuals, there is going to be a representative from the ministry, there's going to be a representative from parks, and I think it's TA, so that they're just there, because we are also stakeholders in some of these things that, in the activities that our operators do. And the issue of the council was a request from our operators because of issues of ethics. So in terms of coming up with it, it was really consultative, because it was not for us, but it was for them, so that at least there are ethical considerations that are taken into place. Because at the moment, we receive a lot of complaints from our clients from the international community due to some of the unethical activities that happen when they come for tourism purposes or to hunt. So the purpose of this council now was to ensure that among themselves, as industry players, there is a way of regulating how they operate. So initially, there was a complaint to say we don't want Zimpax to over-regulate. So we tried to come up with something that they will be in charge of, and we will have some supervisory role, but they will undertake all the activities of handling complaints that come to them as a council. So I think this is what we tried to do here. Maybe through you, Chair, if Madam Chikerema can also come in.
I think you've sufficiently responded, Madam.
Thank you, Chair.
Yeah, maybe to just say that, Honorable Chinanjarana, is that you? No? Okay. Honorable Chinanjarana's point is that there is no clear definition of what a wildlife professional is. We expect that to be in the bill, right? And also, Madam, is there a requirement for the membership? What is the requirement of the membership? It's silent again. Yeah. So there were a lot of assumptions in the bill. Do you want to respond? Please go ahead.
Okay, thank you, Chair. I think to the last two questions that you asked, I think the first point is we say this is merely skeletal. After the bill is now become an act, the Wildlife Professional Council, there is going to be an SI that details all the nitty-gritties. And I think that was on the advice of the AG. And then on the funds, the question that Honorable asked, we merely specified that not more than 30% will be used for administrative purposes. Because we've had issues where in other aspects where there is money, and you find that administrative costs took up 90% of the money. And then the actual business of what it was actually supposed to do could not be done. So we just put a cap to say not more than 30% will be used for admin. The other 70% will then be used for the core business of the council, which is to regulate our wildlife professionals. Thank you, Lord.
Thank you for that response. I think it is very important to note that, like you say, the Act has not been amended for a very long time. And this actually gives us an opportunity to consolidate all the pieces of legislation. So to say, there's going to be an SI that will come. You know, I think on our part as parliamentarians would have not done justice as well. We want to consolidate everything. All these statutory instruments, for example, the SI 362 of 1990 as an example, it has to be included because this is an opportunity to have a new act. So instead of leaving it to have statutory instruments, why don't we clarify all of the issues into this piece of legislation, which is going to be the mother of all the statutory instruments. So please, this is what the honorable members are raising. Let's consolidate. It's an opportunity. An Act of 1975 being amended. Thank you. Honorable Chombo, over to you.
Okay, perhaps I'll start by just buttressing, officer. I'll start by just buttressing what you've just said, that the Parliament reserves the primary responsibility of lawmaking. So take the advantage that we are coexisting so that we be able to incorporate all those things rather than to wait for the usage of certain unfaithful or subsidiary legislation. But I was going to go to clause 16 on administration of funds as far as compensation are concerned. Seemingly, the process here is quite tedious and cumbersome, and the idea of trying to preclude those people who deserve to be compensated, not to be compensated outright, because of the procedural aspect that borders around that particular issue. Why I'm saying so from a background point of view, we've heard about people being attacked by parents in Buera. Okay, for example, they get a down there. Then here the requirement is that there must be a police officer, there must be affidavit signed possibly by a lawyer. This person has been attacked deep in the rural area. Possibly to travel to the nearest police station is about 30 kilometers. Possibly to get a lawyer, the nearest lawyer is in Mutare, it is 300 kilometers. So, Honorable Minister, is that not in the good interest if these people are to be compensated to accommodate the presence of possibly elected councillors, but all of the servants who can be able at least to validate through an assessment that for sure this victim was attacked, okay, and therefore I signed an affidavit to the effect that that person being able to access compensation. Because as it stands right now, this remains elusive for these people to get the desired compensation. So it is my humble submission, Madam Chair, that it can be included, that those critical stakeholders are included as far as this process is concerned. I submit.
Thank you very much, Honorable Chikomo, for that. I think it's clear. Maybe to also bring another aspect into the human-wildlife conflict, because in the bill you are introducing that only the victims of human-wildlife conflict, maybe those in the form of death and also maiming, you know, and maybe permanent disabled, right? So maybe to clarify this part, to say if you are saying that if an animal like a hyena is maybe destroyed crops, like Honorable Kambuzima was highlighting, is there compensation? because you are only speaking about physical injury to an individual. What about damage to property? We've seen in the past, Honorable Minister, where animals invade into these farms, they clear all the crops. And because of that, there will be retaliation killing by the members of the community, because they also want to revenge on animals, causing, continuous human-wildlife conflict. Why is it that the bill does not address the damage to property? That's number one. Then number two, what Honorable Chikombo has highlighted. I was thinking of an example when I was, reading this clause. Let's say somebody has been attacked by an elephant. An elephant is charging to a woman coming from fetching water, for example. They break their leg in the process of running, but they have not been physically attacked. But maybe they're just running away from the animal. How is that going to be handled in case of no physical encounter with the animal? But let's say they've broken their leg, they're now disabled because they're running from a leopard or they're running from an elephant. How do we handle such cases? It has to be included in the bill. You want to respond?
Yes,
Yes, please go ahead.
just to buttress the points that you have really raised, honorable members, that the intention of the Human Wildlife Relief Fund is not to create cumbersome procedures of not wanting to pay. It then defeats the whole purpose of why we're even put it on the ground. The main challenge that we had is how to start it, because we have never had it before as a country. We might have other means in which relief is being provided, but largely on a voluntary basis. So we want a formalized legal means in which we can then provide this relief. We looked at different compensation models across the world and came to a realization that many of them are actually struggling with relief or compensation, as some would want to call it. In Kenya, they've since even stopped the providing relief for damages to crops because of those problems. Zambia also in its law has muted the compensation for property and crops and livestock. The only country in the region that still retains that provisions in law and policy is Namibia, but on the basis that they recrafted the mechanism through which they raised resources for that particular fund. And this is the first country in the world to use their carbon credit for purposes of, they call it a conservation credit. That is similar to a carbon credit, where they actually then go on the international market and sell these credits. And this credit is then linked to tourism and all of that. So any particular sighting of wildlife by tourists, for instance, is then turned into a particular benefit direct to that community, and a percentage of that money raised goes into the revenue for the relief fund. So probably in our I'm admitting that we might have not explained this very clearly in the bill draft, but we've done that. We've got a paper that backs this up, and probably need to bring to the attention of members for you to be able to see the rationale that we use to arriving at this. Then also at the beginning, you require an amount of money that you require from Treasury and also to outside Treasury to have this fund. We didn't want a situation where you agree as lawyer makers to say, this is the law, can you compensate? Suddenly we have to look for the money somewhere. And then it becomes dysfunctional because the fund has got no money. We must start from somewhere. So we said, what is the minimum we could start from before we go to other areas? We learn as we go, and then we implement those for compensation for crops, for our domestic animals, for property that is damaged. We can do that, but we needed to have a very phased approach as we improve on that. So, Chair, we are agreeing with you that there's more we can actually do around that in terms of clarification and building this particular fund. And for instance, if we are going to have a developmental intention for wildlife areas to say, let's have hospitals closer to the people. Sometimes they don't even have venom for snake bites. But it's also a mechanism through which this fund can, if it's not utilized for a particular year, we don't want it to flow to the next year. We said we want a situation where annually this amount of money that is allocated then goes to straight into its purpose, and if excess funds are remaining, they then go into our schools, into our hospitals for educational purposes to prevent, and they work with traditional leaders and councillors around these areas for awareness. Those are the things that we want this relief fund to be vibrant mechanisms for dealing with these matters.
Thank you very much, Professor Matondi. I see Honorable Chikombo. Please go ahead.
Okay, thank you so much, Madam Chair. I just want to possibly supplement on the question that you've already provided to the General Secretary, but obviously using clause 16 then on non-liability of authority. My understanding of this clause seems to suggest that the authority evades accountability, but also issue of liability, as far as these issues that we are talking about are concerned. So I would want to believe that if I kill a python today, it's a custodial sentence. Is that right?
Yes.
And then, how is that possible that the state the authority cannot be sued or can invade or preclude liability? Is it not defeat of rule of law? Where is justice to it? What is the rationale of the state to reach to this position? Maybe I need to be enlightened. Thank you very much.
Thank you very much, Honorable Chikombo. Professor Matondi.
I've got my legal and friend.
Yes, the legal.
Thank you, Chair. Through you, Chair. Thank you, Honourable, for that question. Currently, the current Act subscribes to the res nullius concept, where we are saying these animals belong to all of us and they belong to no one. So because of the fugitive nature of wild animals, which basically means they move from any place, today they're in Zimbabwe, today they're in South Africa, no one is actual control over those animals. It would become very difficult for the authority or even for government to take full liability to say anything that happens to anyone, then the government can be sued. We'll be having a lot of cases. This is why this incoming fund is a way to try to alleviate the suffering that people are going through. But the nature of these animals, they cannot be controlled. So this is where the challenge is. And this is why, if you notice, even the crafters of the current Act, they tried to, they did not put any provision of liability on the part of government because of that. So the nature of these animals is what makes it difficult to then say, so the authority can be liable. So in terms of this fund, as the PSS said, we are also looking at the availability of resources. At the moment, we are trying to come up with various ways of how resources can be obtained, looking at other cases in other jurisdictions. And so we say, if we are to give ourselves this liability, and at some stage there are no resources, and then we've already been sued at some stage, and of course the coming in of cabinet coming up with the amounts that people can be given, even though we don't have an act yet, we've already been giving some people who have been attacked by animals money for medical attention. But for us to take 100% liability, it would be very difficult for us to have those funds when we are sued, or even if someone loses their life, for us to compensate for life. So this is why we didn't run away from the term compensation, because we can never compensate, but we can only offer some kind of relief.
Okay. I'm sure my understanding is that you cannot do that because you do not have funds.
Yes.
Okay.
Is it Honorable Joyce, on this point, is it a supplementary?
I think another question.
It's a new question. Okay, do you want to respond to the same?
Yeah.
Okay, just briefly.
Yeah, okay, thank you, Honorable. Honorable, I think one of the main reasons we had this clause is we wanted it to be very clear that the money that the authority has is not the money of the fund. We even suggested at one point to have the fund be under the Ministry of Finance because we realized the problems it would cause. Because if the authority has money and the fund has no money, it's so easy for members of the public to say, oh, so the authority is using the money for the fund. So we wanted there to be clarity to say, the money, if parks were to take money and put into the fund as a donation or as a statutory obligation, they would have contributed, which they should, because they are also a player in the wildlife sector. But the money of the fund is separate from the money of the authority. So if we create liability for the authority for what happens or the failings of the fund, then the authority will not have any money at all in the event that the fund goes bankrupt. So I think we just wanted to clarify to say the money that is with the fund is not the money of the authority. The authority might administer, but the money that they use for that is not the money that they generate themselves. I think that's why we needed to have that clause.
Thank you very much, honorable members. Maybe to just come back to you, Madam, the legal expert. We should get back to clause 3 on the ownership of wildlife. Maybe let's talk a little bit more on the ownership of wildlife, where this proposed provision tries to settle the critical element of wildlife, where you say that it's ownerless. My question is, what about those people who have bought animals, wildlife, from zoo parks, and they've been keeping it in their private areas? What is the comment on that? Because it's not clear in the bill. And also those that are in large-scale conservancies as well, it's not covered in the bill. So maybe if you can clarify what you mean by wildlife is ownerless. What about those players that have been investing a lot of resources in keeping their wildlife? Thank you.
Thank you, Chair. So what we have tried to do with this clause, as we have indicated, is a new clause. Previously, we did not have it. We've tried to separate 3 scenarios. We've said that specially protected animals, those ones, they are under the protection of the president. We are talking about your rhinos, for instance. And then we have also said that animals which are in the national parks, those ones they cannot have, no one can own those ones. Those ones are moving freely from one area to the other. And even those who have private ownership, they sometimes benefit from those animals because they also move into their areas. But for the people who have purchased these animals, these are the ones that we are trying to cater for in this particular clause. Where on C we have said where a wild animal, protected animal, is lawfully captured or killed or reduced in possession by an animal in terms of a license issued under this act, dominion in that animal or any carcass or trophy of that animal shall thereby vest in such person. So maybe what we might need to do is just clarify that particular clause so that it's clear. But those who have bought, because we do have our operators who have maybe purchased rhinos from South Africa, they've said those ones, they should be able to own those. Because at the same time, a lot of investment is put into wildlife, and we want to recognize that. So the purpose of this was just to separate what type of animals and under what circumstances they can be owned by individuals, by private individuals, and those which cannot be owned. So I think we take your guidance on this one so that we can really clarify it. So if you look at the first part, except specially protected game rules, unfortunately when we do these ones, we'll be guided by the AG. So the drafting essentially comes from them. So the specially protected, those are under the president's protection. And the exotic wild animals, which are in private custody, there are people who apply maybe to have tigers so that they can have them in their private game parks. Those ones, they are also owned by them.
So you're saying, let's say a rhino, for example, is a specially protected animal,
Yes.
then a private player owns it.
If they buy it from somewhere, let's say they bought it from South Africa, but the people who have rhinos in this country, they obtained them from the national parks. So they came from the national parks and they're saying maybe there was no purchase, they were just maybe given to them. I don't know, maybe Madam Chikerima can just clarify on that issue of what happens to purchasing wild animals and those that are given without any payment.
Is there a scenario where somebody can own a rhino without purchasing from Zimbabwe?
Yes.
Okay, so maybe clarify on that point to say who owns the rhino in that circumstance.
Okay.
Yeah. Madam Chikerema, please.
Thank you, Chair. I will try and clarify using the example of the rhino. The reason why I'm using the rhino is, number one, the rhino is on Appendix 1 of CITES, and it's a specially protected species in Zimbabwe. And it's only 2 years ago when we hit the 1,000 mark. So we used to have about 5,000 rhinos in Zimbabwe, but they were poached. Especially if you remember in the 80s, there was a rhino war in the Zambezi where most of our rhinos were purchased. And to reduce, to try and protect the species, the private landowners who had fenced properties were given temporary custody. What it meant was you were given a rhino to intensively manage. And in the 90s, we established what were called the intensive protection zones. This is land on private land and in some protected areas where we have rhinos under intensive protection. And they are the security, they have 24-hour security. So in Zimbabwe, for example, we've got about 1,400 rhinos, white and black rhinos, and 90% of these are on private land. So if we say today the rhinos are owned by someone who's keeping them, it means Zimbabwe doesn't have a lot of rhinos. But we have private properties like the Malilangwes who bought, so in Zimbabwe we have the black rhino, which is in abundance. We have a specific species that is only found in Zimbabwe. But for white rhinos, they do very well from South Africa. So we have rhinos that were imported from Durban. So there are very few properties. I would say Bubi and Balangwe, they bought some rhinos from South Africa. And we are saying for these ones that you bought and they are on private property, these may be owned. But for the private players who we gave rhinos as impacts for security reasons, you may not own these, but you have the use rights. I'll give an example of Imire. Imire's got rhinos that were given by Zimpact. They were given by us for temporary custody. You do not own these. They are owned by the state, but you are benefiting through use rights. And then you also have people who brought in, for example, tigers from South Africa, and they have these in captivity. These you may own, but everything else is our wildlife heritage. We all own those properties. But if you have them on your property, you have use rights, but it's owned by everyone, for the people of Zimbabwe. Thank you.
Thank you very much, Madam. May I kindly ask you, Madam, to come and sit where the PEMSEC is, because I really want to see you as you speak, please. There's a vacant chair. Thank you, thank you. Again, Honorable Minister, these are the contentious issues that are not included in the bill. I think everything has to be clear, because what is happening is you really know what you are trying to address in the act, in the current act, using the bill. So let everything be clear, because right now it's not even clear what she was just elaborating on. So I think it's important so that, you know, because the law has to be clear, so that those who are going to interpret the law, you know, they use it clearly. So thank you very much for that. Honorable Joe, please go ahead. I'll come to you, Honorable
Our legal officer is taking note of the points that are coming up. We will clear it up.
Thank you. Honorable Joe. It's a supplementary. Please, Honorable Makobe.
How are we going to distinguish those animals?
Your mic, Honorable Makobe.
Are we going to distinguish those animals which were given to these individuals like the tax and those which they put on their own? They might, is it well articulated on the bill that with those two categories, and we can easily identify them? Because sometimes people might abuse that.
Thank you, Chair, and thank you for your question. So in the bill, it's not clarified. So, but within these impacts in the system, we issue permits for every animal that we have. And for specifically for rhinos, because they are specially protected, we have annual meetings and we take account of every new birth. So we have a record internally, but it's something that may need to be clarified. Audible. Thank you very much.
Thank you very much, Madam. Honorable Jo, please go ahead.
Thank you very much, Honorable Chair. Honorable Chair, I want to appreciate the Minister for putting all the laws that deals with the wildlife together. But I want to know, Honorable Minister, what was the wisdom in leaving out the SIs, the statutory instruments?
Honorable Minister and your team.
Thank you.
Thank you, Honorable. Through you, Chair. Honorable, I don't think we left them out specifically, but what is in the existing Act is corresponding to what is in the SI. So what we've done is the new things that we've come up with, the advice that we got from the AG was, after this Act has gone through its processes and has been approved, we then go through the process now of aligning our SIs to the Act. So what we've done is in the SIs, there are things that are already in the Act, but there are new things which have never been in the SIs, which will need further SIs, because from the advice of the AG, we put the general concept in the particular Act, and then the specifics, the operationalization of the tiny little things, that is what we then put in the SIs. We are actually going to have new SIs. For example, we did not have human-wildlife conflict, we did not have the quota, we did not have the expansion of the appropriate authority. All these are new. So after the Act is actually been finalized, we then go on to the process now of ensuring that, for example, our principal regulations, they are now cleaned up so that they reflect the new position of the Act.
Thank you, Honorable Chair. I think here, Council, I think you just need to include that, like what you did on the beginning of the bill, like you mentioned that you are including all the Acts.
Yes.
How about the SI? I think you need to mention.
Thank you very much.
Yes, thank you, Honorable Jo. I think we discussed, we talked about that point to say let's consolidate all the statutory instruments, the acts and everything, right? And I even gave an example of the statutory instrument 362 of 1990, right? Yes, so let's include, this is the point that the Honorable Member was highlighting. Honorable Mrombezi, please go ahead.
Thank you very much, Honorable Chair. I'm going to write on clause 45, which gives discretionary power to the Minister. Honorable Chair, the Minister has been given the discretion to approve mining operations with some limitations in areas where game is kept. The criteria for approval is not explicitly defined as we see in the proposed bill. I think this lack of clarity could lead to inconsistent decisions and potential challenges, Honorable Chair. I'd like to hear more with regards to that. Thank you very much.
Again, Council, please may you respond to the Honorable Member. Thank you, Honorable Mrombezi, for raising that pertinent issue.
Thank you very much, Chair. Thank you for the question, Honorable. I think we will try to clarify and to add further. What we are simply trying to do is we faced a lot of challenges in terms of mining in the past, and there was some areas which were not clear. So I think our main focus was just to clarify the role of the Minister and who approves what. But I think with your suggestion, we're going to ensure that we really clarify so that there's no confusion. Thank you very much.
Thank you. Honorable Chikombo, please go ahead.
Okay, just a quick one. I'm writing on clause 11, which seeks to criminally penalize those who are involved in hunting in and removal of animals. So I don't know what then happened when someone buys these animals and need to transfer from one point to the other. Is there no ambiguity to upset it with the interpretation of this clause?
Through you, Chair, thank you, Honorable. If you can allow me maybe for Madam Mansoda to come in. I think which we are seeking clarity on the issue of the removal.
Thank you, Madam, and thank you, Honorable, for your question. So on clause 11, what we're trying to do there is to include the recreational parks. If you look at the current act, it's silent on the issue of recreational parks, on hunting in the recreational parks. So what we tried is to include recreational parks there. So if you, I'll look at Lake Chivero, for example, with wildlife in Lake Chivero. So what we are now criminalizing is the hunting of wildlife in that area. But in the event that there's need for us to intervene or manage, that is provided for under the issue of management of wildlife.
Yes, but I was talking about
Right, Honorable.
I was talking about the issue of removal of animals. My interpretation of it is that animals.
Can you use the mic?
Okay.
Sorry.
My understanding is that, you know, animal ought to be transferred, of course, legally, from point A to point B. So what does this clause 6 to Q1?
Maybe my colleague would want
Yes,
to
please go ahead.
Okay, teacher, thank you, Honorable. Oh, I think this clause is very simple. You're only allowed to hunt in safari areas. You can't hunt in recreational areas. So we cannot talk about removal because you're not even supposed to hunt there. If you hunt, you've already committed an offense. So we will find that as it is today, if someone were to hunt in a recreational park, we don't actually have a law that criminalizes that. So we're just incorporating recreational areas to say on all the areas you can't hunt like national parks, a recreational park is now included as well. That is what that clause 6 to do.
He's speaking on the removal, right? Okay, so it's clear.
They're not actually allowed.
Yes, okay. Thank you very much. Thank you very much, honorable members. Honorable Makope, please go ahead.
Okay, thank you, Honorable Chair. May I have a clarification on the definitions? That some small technical definitions, probably we can clarify on that. For example, the fish is defined separately from any animal, yet fish is also an animal. Then we have the wildlife and the animal. There is an overlap, those definitions, the two. Probably you can clarify on that. Then the alienated land, especially the communal lands, where they sometimes merge this, parks or wildlife lands. How do we define them or differentiate them? Because it's not very clear in the bill.
Thank you, Honorable Makope. Over to you, Madam.
Thank you, Chair. If Madam Adisoza can come in on the definition. Madam Adisoza.
Thank you, Chair. And on the issue of fish, so in the original definition in the Parks and Wildlife Act, fish was excluded. So what we are now doing is to include fish, because fish is also a wildlife. So we are just including fish, because in the original Act, it was excluded. So on the other definition is on animal. So wildlife and animal, I'm sure it was used interchangeably, but in this Act, we are repealing the original definition of animal, and we are we are adding it to mean any individual wild or domesticated wild animal, whether vertebrate or invertebrate, or the species thereof, and whether indigenous or exotic, and the eggs and the young thereof. So in the original, with the Act, it was there, but it wasn't clarified, so we simply clarified in this new bill.
Madam, are you saying, when you say domesticated, are you saying a dog is not part of the wildlife?
No, it's domesticated wild animal. So for example, yeah, here in Harare, if you go to What is Life, the one near the airport, there we have wildlife in extensive in a national park, but they have wildlife in captivity, and they have wildlife that is tame. So that is what we are using. We are taming domesticated. So we've tame wildlife, which is what we are calling domesticated, but not dogs. Yeah. Thank you.
Yeah, so it has to be
It needs to be
clarified
very
as well,
clear.
yeah.
Yeah,
To say it's a wild animal that has been domesticated.
But it's still wildlife, but yeah.
I get it.
Thank you.
Yes, please go ahead.
Okay, thank you, Chair. I think we also had issues previously with exotic animals. In terms of our old act, it really didn't say anything. So if you were found in possession of an animal that is not endemic to Zimbabwe, if you were found in possession of a tiger, that was not classified as a wild animal in terms of our old definition. So we are saying it's wild, exotic, or domestic. So now it covers both. Even if an animal has come out, and as long as it's a wild animal, even if it's exotic, the act now covers both.
Yes, sorry, just a moment, I was just reading what is in.
Thank you.
So to follow up to my question.
Just hold on a little bit, Honorable Minister. Please, Honorable Makope, go ahead.
Okay, on the issue of fish and the animal, I'm not getting clear. I'm saying, the definition of an animal, if you look at it, it encompasses fish already. But in this amendment, fish is now being defined separately as if it's not an animal.
Sorry, maybe my colleague would sorry, thank you, Chair. There's the issue of animal, there's the issue of wildlife. So maybe we just need to clarify, there's one that excluded fish, but in this bill wanted to include fish as part of wildlife. So we might just want to, do you want to add?
Please go ahead.
Thank you, Honorable. We also have issues of contestation with regards to the Ministry of Agriculture, Lands, Fisheries. So we are saying when we are talking about fish that is found within all those areas, your Lake rivers, your Osborne dams, the water bodies that are actually gazetted in terms of the Parks and Wildlife Animal or Parks Act. So those would be termed as wild fish. Whereas you then have other fish that are found possibly in dams and all of that. So we wanted to create a situation, and we had guidance of the AG and this one also to say we want to avoid a situation where we seem to be pulling in different directions with the Ministry of Agriculture. So the Deputy AG just said we need to put your definition of fish in your act so that when we are talking about fish found within those protected areas that are gazetted in the act, you then have your own definition there. So that's how we came to have that definition in there.
Thank you. Maybe we could have called the AG, right? Yeah. Thank you very much for that clarification.
I just wanted to say,
Honorable
the
Minister, please, you might go ahead.
the definition of fish is given in the amendment, so that there is no doubt of what we mean by fish. So fish includes vertebrate fish and aquatic mollusks and crustaceans, both indigenous and non-indigenous. But it does not include the Bilharzia snail, etc., etc. And also it's added that it should be within the wildlife estate, not in your fish pond.
Thank you, Honorable Minister. I think we need maybe consultations on this one, right? And also to just look at also international definitions. They can also help us how we define fish, how we define animals and wildlife. Simple and clear definitions. But thank you for that. Honorable Joe, your hand is up.
Thank you very much, Honorable Chair. Honorable Chair, clause 31 on subjectivity in problem animals classification, Honorable Chair. I'm going to quote the definition of problem animal, subsection 1, subsection D, includes causing annoyance, I quote, inconvenience and discomfort. Honorable Chair, this subjective term could lead to inconsistent application and potential abuse of the animals, Honorable Chair. I don't know if you can revise that. Thank you.
Madam?
Yes, Madam Kerema,
Okay, thank you, Chair. I think we have, again, I'm sorry I have to refer, but we have an SI, and Madam Kerema and the team here, they constantly update that SI because the status of animals is not really static. Sometimes baboons are problem animals. In other instances, now probably because people have unleashed their wrath, they now become endangered. So the SI is constantly updated to cater for the changes within the environment, to say what we once considered a problem animal is probably not a problem animal anymore, and what we considered as a protected animal is probably becoming a nuisance now. So I think the scope of that clause was not necessarily to open end which animals were treated as problem animals. The scope of that clause was to say who has to deal with problem animals, to avoid having people take the law into their own hands. That's why we say the people who deal with problem animals are either the Personal Life Management Authority or the appropriate authorities, which are the RDCs and all of that. So the main scope was to limit in terms of who deals with problem animals, because if we say people can do what they want with the problem animal, it will be open season, and before long, these animals will then become endangered. Thank you, Chair.
Supplementary.
Through the chair.
Supplementary.
Oh, okay.
Supplementary question?
Thank you, Honorable Chair. So, my learned friend, do you mean to say the SI is more superior than the regulation?
Yes, Ms. Elizabeth, please go ahead.
Okay, thank you. I think, like you said, it's actually very convenient that the Honorable has asked this question, because what we have essentially said is, after we have this bill become an act, we are going to have to go back to each and every SI that we have to make sure that it conforms to what the bill says now, and to see how best we can then address these issues as and when they arise.
Professor Matondi.
No, yeah, I think we totally agree. We need to clarify that area. The issue that is being raised is the wording, because it says annoys, inconveniences, and discomforts. So it's very easy. It's very specific to what he's asking. So it's a question of the wording that we use. So we'll clarify that.
Thank you very much, Prof. Maybe let's just get back to when you say appropriate authorities or delegated appropriate authority, right? Let's talk a little more about that, Honorable Minister and team, to say what is the reasoning behind giving 2 levels of AAs to both being given by the Honorable Minister, because she's the one, or the Honorable Minister gives the AA, or the delegated appropriate authority. What is the reasoning behind these 2 levels of AAs? It's close to.
Yeah.
It's part of close to where you define appropriated authority and delegated appropriate authority.
Yeah, we were quite careful on what we mean by appropriate and delegated authority. We wanted to avoid the danger that if you have got a private owner, for instance, then they assume appropriate authority of delegating to others. And we want to delegating to others. So that's what we wanted to avoid. So that the authority becomes one authority that gives appropriate authority and the delegated authority. And that then does not make any entity a right on its own to have its own powers to delegate. That's what we wanted to avoid there. Maybe legal counsel, you can come in and assist.
Thank you, please, through you, Chair. So, the current section 108 is very limited in scope. So what we tried to do was to also address some of the challenges that we were facing in terms of appropriate authority. So the first tier will go to RDC, the second tier will go to communities, issues to do with campfire, issues to do with community arrangements. I think as we speak, we already have some of the examples that Madam Kerema gave of some community conservancies which are there. So when we did the consultations, there were a lot of complaints from communities that they were not really happy with their interactions with the RDC. So as part of devolving, we thought that we should then have a system whereby communities could also have some appropriate authority which would flow from the RDCs as well as policing parts. So the purpose of coming up with these 2 tier levels was to also incorporate communities their own community arrangement where they are also participating in issues of wildlife conservation. So that was the rationale behind the two-tier approach. Thank you, Madam.
Thank you very much, Madam. Like we have been saying in this meeting, that everything has to be clear to say what is the scope of the AA, for example, and also the delegated one. Where do they start from and where does it end? So I think all those things have to be clear, because here it's just mentioned, but there's no clarification to elaborate on who is appropriate authority and who is the delegated one. And also that example we've mentioned to say some authorities, the councils are given appropriate authority over others. Why, segregating the, different councils, something like that. So it has to be clear what we mean by the AAs and also the delegated one. So, yeah. Honorable members, I'm just looking at our time. This is 1:10 Is there any burning question? 2:10. Is there a burning question before we close this session? Honorable Makobe, I see your hand is up.
Okay, not really burning, but let me ask you because we things.
Go ahead and please switch on the mic.
When we look at clause 16, there is a silence on the issue of transparency, on the publishing of council decisions, even their financial books. It's not very clear there how should they go about it. Then there is also no mention of the issue of adapting to the new changes in the bill. For example, reviewing the professional council structure for the mandate. For what time or how they can review that structure. Because probably that I can get clarity in the bill whether we can have that mentioned in our email.
Please, go ahead.
Thank you, Chair. Thank you, Honorable President. We will edit if, since we have omitted it, I think that the advice that we want that let's consolidate everything. Some of the issues we were thinking that we'll put it in the exercise, but we will edit in the main. Thank you.
Thank you very much, Madam. Thank you, honorable members, for such an engaging discussion. Honorable Chikombo, please. Okay, this is the last question.
Yeah,
Yes.
it's very last. I just want to seek clarity, Madam Chair, on Mavrado Nawal's part. I understand that there is a season instrument 6 of 2017 which placed it under Ministry. But there are lions, buffaloes, there are also women in education. What is the board interpretation on that? I submit.
Thank you. Madam Shikirema.
Thank you, Madam Chair, and thank you for the question on the Mavradona Wilderness. So Mavradona Wilderness was declared a wilderness area under in 1987 through the Ministry of Local Government. So this is an area that is it transcends these Muzarabani RDC and the Gurube RDCs, and in this area it's leased. There are certain portions, the copy area, which are leased to certain operators who are into wildlife. But from the park side, we have the Tingwa Rafia Palm Botanical Reserve inside the Mavradona Wilderness. So it's an area which is about 4 square kilometers inside the Mavradona Wilderness. But this is an area that is managed by the Ministry of Local Government through the RDCs. But there are areas that are leased with wildlife. But it's not an area, it's not a gazetted area under the Parks and Wildlife Act. So there are a certain portion that is under the Parks and Wildlife Act, but the larger part is under the Ministry of Local Government. But it would be good if the area may be designated a parks estate, because of the wildlife, it will make more sense. Because this is an area where the whole central region, there are rivers emanate from those wilderness. That's an area that I've seen the most clear water in Zimbabwe. And if the major challenge in Mavradona is the chrome mining. So the chrome is having a negative impact in the wilderness and also on the water source for all the communities living in that landscape. And yes, it's under Ministry of Home Affairs, but I think if we could manage that area, it would be better, because that's an area where we also have leopards coming in as well. It's a wildlife corridor for elephants coming from Mozambique into Nyatana, Mavradona, into Mfurudzi. So it's a very good area for wildlife that needs to be protected. Thank you, Honorable, for raising the issue of Mavradona.
Clarity? You want to say clarity? Yes, quite Honorable Joe.
Thank you very much. Sorry, Honorable Chair, I'm going to pose a question which is different from the one which was posed by Honorable.
Please go ahead.
Thank you, Honorable Chair. I just want to find out, Minister, why is the values of the animals when someone is prosecuted is different from the one when you are selling the animal, the wild animals? Like if someone is prosecuted for a buffalo, the buffalo maybe is charged 10,000 USD. When you are selling the buffalo to maybe private players, you are selling it maybe 2.5 or 5,000.
Yes, that is deterrent.
It's a compensation.
Compensation. We don't want people to be tampering
Please
with
use the mic, Honorable Minister.
That is deterrent, Honorable Minister. Because if we make it equal or we make it less, there will be more people poaching and killing our animals.
Thank you, Honorable Joe, for raising that question, because I think there's also a question of negligence, right? To say, like the penalization of those who negligently kills the wildlife, but the proposed punishment is too high, right? So I think we also need to balance. Let's say, for example, you are asked to hunt for a female buffalo. This is the question. Then you accidentally kills a male buffalo. Then you're expected to pay 5 times the cost of the buffalo. I think this is where the question is coming from. You know, to say what is the rationale around, you know, that killing of an animal. So I think this is where it's emanating from.
Again, Honorable Chair, it is these decisions were made out of research. To say really when you then investigate, you find it was not a mistake. It was intentional. And then if we really investigate, this is why in the bill now we are saying there will be thorough investigation. If we investigate and really find it was not intentional, there will be no problem. But in a lot of cases, the mistake is not a mistake, it's deliberate. And we stand here to protect our animals. Thank you, Madam Chair.
Thank you very much, honorable colleagues, for such an active engagement this afternoon. Allow me, ladies and gentlemen, honorable members, to thank the Honorable Minister of Environment, Climate and Wildlife, Honorable Dr. Stempelmani. Let me also thank the Permanent Secretary in the Ministry of Environment, Climate and Wildlife, Professor Matondi, and colleagues from the ZIMPACs, Madame Chikerema, Madame Mochkambizi, and also Madame Mr. Chadenga. I would want to thank you for your input, for all the contributions, the clarifications, you know, the insightful contributions you've made this afternoon. Thank you very much for coming before this committee. We look forward to more engagements. We know that this is one of the many bills that are going to come from the ministry. So we look forward to many more engagements. And let me also say that we are also going to embark on our own consultations as Parliament of Zimbabwe, which we are supposed to do. We are going to engage stakeholders, communities, to go into the communities to also hear what their contributions are in terms of this bill. So thank you very much. If there's need, we'll then call you back to the committee to also, put across some of the deliberations that would have come from the members of the community and also the key stakeholders. But for today, allow me to thank you, and you're kindly excused. Honorable members, thank you very much. Our stakeholders, thank you. And also members of the media, thank you very much for coming. This is